What's up, everybody? Welcome back into another episode of The Lawyer You Know. And there's so much going on in this Karen Reed case. But the most important thing to hit over the weekend was what is going on with her lawyers. We saw Hank Brennan and the Commonwealth try to get their pro hoc vice pulled, try to get them struck off the case with sanctions for, lying to the court, all sorts of things. Didn't happen. We saw the Commonwealth and Hank Brennan add her defense lawyers to the witness list. Is that going to get them removed? We're going to look at what the rules are in Massachusetts about that. And then now he wants their privileged communications and text messages between Yanetti and Karen Reed, saying she waived her privilege in front of a national audience, and now the Commonwealth should get access to all that. How will that affect this attorney-client relationship? Are they in jeopardy of being removed from her defense team? We're going to talk about all that and more on today's video, so make sure you guys hit the like button and settle in. Here we go. So we hit the sanctions motion ad nauseum. We are going to talk about the lawyers being on the witness list. I did a tweet about that. It's kind of an easier conversation. We'll discuss that, but this was the most important thing to come out that we haven't talked about yet. So let's read through the Commonwealth's motion here to compel communications between the defendant and attorney Yanetti stored within the defendant's cell phone data. So it's a motion to compel. Usually you file a motion to compel after you send a discovery request. The time goes by, the defense doesn't answer it. And then you send a 10-day letter. You say, hey, give me this discovery. I'm going to file a motion to compel. They don't give it to you. Then you file the motion to compel. I don't know if in Massachusetts it's different. You just skip to this if it's attorney-client privilege communication, because usually you don't get that, or because it's so close to trial happening in a week that they're trying to really move this thing along. But either way, this is where we are. So let's take a read here. The Commonwealth seeks all, and this is the crazy part, the Commonwealth seeks all text messages, emails, or written communication between the defendant, Karen Reed, and attorney David Yanetti, restricted to those communications that occurred between January 29th, 2022 and February 2nd, 2022. By the way, the voice is not quite back, but we're doing our best to push through. And the crazy thing about this is how broad this request is, based on where we're going and where he's getting the waiver from. But what's the footnote say? Pursuant to a search warrant, the Commonwealth received the contents of the defendant's cell phone. Because of an observed attorney-client privilege communication, the phone data was provided with the assent of the defense to the Attorney General's office, and a court-ordered taint team protocol was implemented. That means somebody looks at it. If it's privileged, they put it in one box, and they put everything else in a box that goes to the Commonwealth. The Commonwealth received the defendant's phone data with any privileged communications excised, given the defendant's public waiver of the attorney-client privilege as it pertains to the defendant's conversations with attorney Yanetti on January 29th, 2022, and the following 3 days. It's important to see the timeline they're giving. The Commonwealth is entitled to the communications between the defendant and attorney Yanetti for this waived narrow period of time. And they're using that language saying they're narrowing it because that gives them a better chance for the judge to say, okay, I'm just going to give you this narrow waiver that she intentionally waived, and I'll give you some of that information. If you try to make it seem like a broad waiver overall of attorney-client privilege, there's no way you'd ever win that. I shouldn't say there's no way. Not with the facts we have here. The privilege holder, Karen Reed, has waived her attorney-client privilege with attorney Yanetti relative to any statements about her collision with John O'Keefe during the time of January 29th to February 2nd. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. The communications confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them. To ensure that only, and again, they keep narrowing it to tell the judge, like, we're only looking for what we really should get. To ensure that only the communication that were waived are provided, the Commonwealth requests the Honorable Court review in camera all text messages and written communications stored in the defendant's phone data for the time between January 29th and February 2nd. So they want the judge to look and say, here's what you can have, here's what you can't have. In support of this motion, the Commonwealth acknowledges and respects that the attorney-client privilege protects privileged communications between a client and his or her attorney. And they cite Massachusetts Rule of Evidence 523, which explains how and when you waive your privilege. So first, who can waive? A privilege holder or the holder's legally appointed guardian, administrator, executor, or heirs can waive the privilege. In this case, Karen Reed is the privilege holder. Conduct consulting a waiver. Except as provided in Section 524, privileged matter disclosed erroneously or without opportunity to claim privilege, a privilege is waived if the person upon whom this article confers a privilege against disclosure. So basically, as long as it wasn't accidental or erroneously waived, okay? Voluntary disclosures or consents to disclosure of any significant part of the privileged matter. So that's what we're trying to determine. Did Karen Reed voluntarily disclose or consent to it being disclosed, meaning she told Yanetti, go ahead and tell him what I told you. Or she signed something saying, yeah, I'm going to waive. This person can talk about it. That's consenting to or voluntarily disclosing information. Or introduces privileged communication as an element of a claim or defense. What's conduct not constituting waiver? A person upon whom this article confers a privilege against disclosure does not waive the privilege if the person merely testifies as to events which were a topic of a privileged communication, meaning I talked to my lawyer about the fee. I talked to my lawyer about the facts. Well, that doesn't mean you then have to disclose what the fee is or disclose what those facts are that you said I talked to my lawyer about. It's not specific. It's generally, here's some events I talked to my lawyer about. Or there is an unintentional disclosure of a privileged communication and reasonable precautions were taken to prevent the disclosure. Somebody stole Karen Reed's phone and somebody looked through all the texts and somebody screenshotted them and posted them on Twitter, right? She tried to not get her phone stolen. She tried to keep anybody from seeing those texts, but it was stolen. It was taken. It was unintentional. That didn't happen in this case, but I'm saying if it did happen, then that would be an unintentional disclosure, and therefore the privilege would not be waived. So let's figure out which one it is here. In this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding specific conversations she had with attorney Yanetti regarding the collision between her vehicle and John O'Keefe. For example, in the defendant's recorded interview with Gretchen Voss on June 20th, 23, the defendant concedes, question, you never said, did I hit him? I hit him. Answer. I said, and this was from Karen Reed, did I hit him? Kind of admitting she said that. And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's culpability there. And I thought, all right, maybe this is maybe I said to my mother, just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like? Attorney Yanetti, Attorney Jackson, and Attorney Little were in attendance along with the defendant and Ms. Voss. So it's clear as day, an intentional waiver for those comments, in my opinion. And she had the opportunity to conceal them. All of her attorneys were sitting there, multiple third parties in the room, and to a national audience, even international audience, she said very specific things she and her attorneys discussed back and forth. Second, in a Vanity Fair article, Karen Reed tells her story, a murder trial in Massachusetts, with a caption, as Karen Reed's second murder trial looms, she's ready to talk about what she says really happened. Published on October 29, 24, the defendant, who according to the publication was notably aware that anything she said could be used against her. Once again, she knows how this works. This is not a trick, or this is not something that was coerced out of her. Volunteered a rumor that alleged representations made by the Massachusetts State Police that there is a text message between her and counsel that implicates herself is a provable lie. So they're going to say what Brendan is trying to set up is the I hit him, I could have hit him is a text that implicates her, and that her saying a lie, that's a lie, is actually wrong. They're going to try to use these statements to impeach her other statements. Third, in the now airing 5-part docuseries on Investigation Discovery and HBO Max, entitled A Body in the Snow, The Trial of Karen Reed, the defendant professes, and then when I hired David Yanetti, I asked him those questions the night of January 29th. Like, David, what if I don't know, what if I ran over his foot? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. So why is that about 3 days important? Well, she says she made those comments to David Yanetti on January 29th. And the Commonwealth is looking for text messages, emails, written communication 29th, 30th. How many days are there in January? 31st, all the way through February 2nd, right? So they're saying that everything Karen Reed said over those next about 3 days is important to the waiver because she references it, she discusses it, and she is using it basically in these interviews to try and prove her innocence. So the night of the 29th could be the 30th. I looked at my phone. There's 31 days in January. I'm horrible at that, by the way. Besides February, I never know how many days are in a month, except October, of course, too, and December. So 31. So that goes 29th or 30th, 1st, 31st, 1st, 2nd, right? Still feels like more than 3 days. So maybe the court, if they're going to strictly construe this, 29th, 30th, 31st. So she wouldn't get, or they wouldn't get what's on the 1st and 2nd. But that's why he extends it past January 29th. The privilege holder is the defendant, and the defendant intentionally waived her privilege by disclosing her conversations to a nationwide audience with her attorney. The attorney-client privilege can be waived only by the client. In addition to rendering the communication non-privileged, the communications are relevant as admissions and statements of the defendant. These statements are admissible substantively, and Attorney Yanetti's statements to the defendant are admissible pertaining to the defendant's state of mind. Also, the defendant's admissions and Attorney Yanetti's statements are relevant to challenge the defense's later purported claim of third-party culpability. The communications have relevance to rebut the defense's potential claims that some other person committed the crimes that caused the death of John O'Keefe. Moreover, the defense has suggested that as part of its defense, it is likely to pursue a Bowden-type defense. Bowden. The potential evidence is relevant to rebut claims of law enforcement contraventions. So every time I see Bowden, by the way, Bobby Bowden, Florida State guy, I'm going to read it as Bowden. So they say this proves third-party culpability is not true. The defense will have the opportunity potentially to discuss, do we want to put more of Karen Reed's statements in? Rule of completion. You're not allowed to testify through an interview because they have to have the opportunity to cross-examine her. But if they're going to put in part of a statement and you have to give it context, they'll argue about how much should actually come in, because I haven't watched the most recent interview. Actually, I haven't watched either, I don't think, because I was under the assumption none of it was going to come in. If it's going to come in and be part of this trial, maybe I will watch some of it. But maybe some of it will come in to explain and make sure they're not pulling these statements out of context. But the way I read this, Karen Reed, in my opinion, absolutely, intentionally, and fully waived her attorney-client privilege with respect to a very narrow topic, phrase, sentence, fact, whatever you want to say. I absolutely don't think she waived it for the 3 days because she said, that's how I thought about things for 3 days. She did not waive everything they spoke about over the next 3 days. In my opinion, this is my opinion reading it, reading the case law, reading the rules of evidence in Massachusetts, and with my experience about these kinds of waivers. I think she waived it specifically January 29th, discussing did I hit him and what Yanetti said about culpability. Now, there's also the big question of, is there even any written communication? Are there text messages? Are there emails? Are there handwritten letters that they have? I don't know. I don't know what is out there and what's available. That's not the question at this point. The question is the Commonwealth entitled to whatever is there if it does exist? And in my opinion, they would only be limited to January 29th, specifically talking about, did I hit him? Could I have hit him? And what Yanetti said. And that could be bad, right? That could be bad because then they can talk about the defendant's state of mind. That's where they came up with this whole defense. That's where they came up with the third-party culprit. Right then and there, they talked about it. She figured out, if I hit him, my attorney said there's culpability. We got to come up with something else. And that's why we're here, members of the jury, with this unbelievable conspiracy that all these great cops and great prosecutors and great people involved, they say they're all in a conspiracy. They're all coming and lying. ATF agents. Come on, members of the jury. This is clear. Don't be tricked by the defense team. They were discussing it as early as January 29th. She knew if she hit him, her own lawyer sitting there at the table with her said, well, then you've got culpability. And guess what? He's right. You can use that. It's going to be very powerful to use a defendant and her lawyer's words against her at trial. And I do think the Commonwealth is entitled to that. If she's going to put it out there for the world to see, she is waiving privilege, in my opinion, to that limited amount. So in conjunction with this, the Commonwealth is also trying to get records from Unsolved Productions, Inc. They want him to produce the records about a docuseries that they made in support. The Commonwealth states the following. June 9th, defendant was indicted. Jury trial happened. March 17th, 18th, and 19th of 25. Investigation Discovery and HBO Max aired a 5-part docuseries entitled A Body in the Snow, the trial of Karen Reed. The aired docuseries is approximately 4.5 hours of behind-the-scenes look at the defense team as it prepares for the April 24th jury trial and features extensive interviews with Karen Reed, Jackson, Yanetti, and Little. Terry Muir, president of Unsolved Productions and the producer of the 5-part docuseries, has described in the media interviews that the access to the defendant and her defense was unprecedented. As part of this docuseries, the defendant and her counsel permitted cameras to record their trial preparation sessions in the war room, car rides to and from the court, where the defendant and her counsel discuss upcoming testimonies and trial strategies, often evidence, the prosecutors or the court, and one-on-one interviews with the defendant and defense counsels. Every statement made by the defendant pertaining to the facts and circumstances surrounding the death of John O'Keefe is relevant and evidentiary, especially given the nature of past statements made by the defendant. In this 5-part docuseries, the defendant again makes inconsistent statements with previous statements she had made to law enforcement, witnesses, and most revealing to other media reporters during other voluntary interviews. For example, the defendant now claims that she unequivocally saw John O'Keefe enter 34 Fairview Road and admits to consuming large amounts of vodka and being significantly impaired. Her position, even within this 5-part docuseries, waivers from a claim that she remembers every detail on January 29th to admissions that maybe her memory wasn't as clear where she had been drinking. The defendant confirms animosity in her relationship, confirms the altercation with Marietta Sullivan in Aruba, which they've already said they're not going to use. So that's not relevant. Confirms her flirtatious text with Brian Higgins. Confirms she was angry with John O'Keefe and convinced that John may have been cheating on her with another woman who resided in the neighborhood around 34 Fairview Road. The defendant further discusses going to John O'Keefe's residence during the morning of January 29th and mocks Mrs. O'Keefe's opinion that John looked like he'd been hit by a car. Contrary to representations made by the court on March 18th, by the way, I saw that clip circulating Twitter. The defendant admits on March 17th aired episode that she used an intermediary to share discovery with Aidan Kearney, then with permission of her defense counsel, shared public information, presumably all discovery, provided to the defense that would ordinarily not be deemed public due to the investigatory nature of the prosecution with Mr. Kearney. Mr. Kearney then used this material to advance the defendant's narrative and direct harassment of witnesses. She further admitted that she spoke with Mr. Kearney regularly about her case. Further, contrary to representations made to this court on March 18th episodes, the defendant expressed reckless indifference that the witnesses, many who came to the defendant's aid, have been intimidated and harassed, and the defendant stated, Jen McCabe, it's me or her. Either I'm going down, Jen, or you are. The 5-part docuseries is also ripe of new information previously unknown to the Commonwealth. For example, the defendant's statement that John O'Keefe exited her vehicle holding her vodka soda drink, that she clearly saw John's body from Carrie Roberts' vehicle, and that she pulled a small piece of glass from John O'Keefe's nose. The defendant further reveals her initial beliefs in the immediate aftermath of John O'Keefe's death, stating to attorney Yanetti and waiving any associated privileges. What if I ran over his foot, or if I clipped him in the knee, he passed out and went to care for himself and threw up or passed out. The defendant repeatedly used the media to promote her position, explicitly stating in a Vanity Fair article, okay, we already read that, various media interviews, the victim did not appear, and stated in mixed submissions that the victim did not appear mortally wounded, that she thought she clipped and unknowingly incapacitated the victim. Further statements are likely relevant when compared to the past statements. Defendant statements are not hearsay and are instead substantive evidence admitted for its full force of proof. When a defendant deliberately undertakes a public relations campaign and saturates the public and the potential jury pool with statements likely to reach the potential jury pool, they also run the risk that statements may not be beneficial and be incriminatory. The helpfulness or unhelpfulness of the statements does not direct legal basis for disclosure. The unaired statements made by the defendant and her counsel would be relevant and material to put the relevant aired statements, many of which will be introduced at trial, in context. Further, the absence of details provided in the unaired footage is fertile grounds for examination of witnesses at trial. Pursuant to Massachusetts Rule of Evidence 801 D2A, Commonwealth seeks to introduce multiple statements made by the defendant A defendant's statement is not hearsay and is admissible against the defendant when the statement is made by or adopted by the defendant. It's true. That's just simple black letter law. In Massachusetts, it's well settled that news reporters do not have a constitutional-based testimonial privilege that other citizens do not have. No qualified journalist privileges that protects against disclosure of confidential and non-confidential press materials. Even if such privilege did exist, parties seeking disclosure of non-confidential materials are entitled to seek discovery from a media entity if they can show the materials at issue are of likely relevance to a significant issue in the case and are not reasonably obtainable from other available sources. I don't know if the judge has already ruled on this one, but I assume she's going to let them get this just like she let them get all of the other information from these other interviews. But the purpose of reading this document for this video is anything Karen Read said in any of these documentaries or any of these interviews is admissible, in my opinion, as her statements, as long as they're relevant. And anything she said that she told her lawyer will be a waiver of attorney-client privilege. And I do believe that the Commonwealth will be able to use and get into as much as they can prove she said out to the masses, that she said to the world in these very public interviews, to interviewers, to different people, anything she said to Turtle Boy that maybe her lawyer told her, that's a third party intentionally waiving the privilege. That is going to be something I believe the judge finds. But it should be as absolutely narrowly construed as you can possibly do as a judge. You don't punish a criminal defendant for giving an interview by saying, now you've waived all attorney-client privilege. That to me would be an easy issue for appeal. But specifically, did I hit him? Could I have hit him? If you incapacitated him in any way, you could have some culpability. That is admissible. That is something I believe the Commonwealth should be able to use in trial number 2, because I believe the defense team as a whole made a conscious decision to allow that, to do that, to say that. And I believe there's been a big time public push behind Karen Read. And I think a lot of the interviews and a lot of the PR stuff they're doing is working. People are seeing corruption. People are seeing issues. People are seeing holes in the evidence and the investigation. But it hasn't come without its challenges and without some risks. And this was one of the assumed risks. And the Commonwealth is doing a much better job. I always wondered in the first trial why Lally didn't use anything from any of the interviews. I thought that was kind of wild. That's usually just amazing. Usually you use a ton of it. He didn't. I think Hank Brennan's going to use a lot of it, which is just another illustration about how different this trial is going to be. Now, the lawyers were listed on the witness list. So let's take a look at Rules of Professional Conduct 3.7, lawyer as witness. A lawyer shall not act as advocate at trial in which the lawyer is likely to be a necessary witness unless the testimony relates to an uncontested issue, the testimony relates to the nature and value of legal services rendered in the case, or disqualification of the lawyer would work substantial hardship on the client. So let's take each one of these in turn. What will read be? A lawyer may act as an advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded from doing so by Rule 1.7 or 1.9. So let's just break down A for a second. A lawyer shall not advocate at a trial in which the lawyer is likely to be a necessary witness. That is the important part. Necessary. Can you get this information elsewhere? From another witness, from a document, to where it's not necessary that the lawyer should testify? To me, it's easy in this case that these lawyers are not necessary witnesses to anything. They can get this information from the documentary itself, from the interviewer, if that's what they're going after. There may be other things we don't know, and we'll be open to getting more information and developing what our opinion is on this. But I don't see them as necessary witnesses. That's number one. Is it an uncontested issue? Will the lawyer say, sure, if she hit him, she has culpability, but she didn't hit him? That's not a contested issue. I don't have to be bounced from this trial. We all agree. And then number 3, disqualification of the lawyer would work substantial hardship on the client. At this point, we're going to trial in 1 week. If she was going to remove Yanetti, Little, Jackson, anybody else, any of those lawyers, I would argue, That would be a substantial hardship to the client and the defense. I know you could say they have 4 lawyers. They divide and conquer. They're each handling parts of it. They'll be fine. They can pick up the slack. I think that's foolish, and that's just not how it should be looked at. And a disqualification of any of these lawyers at this point would be a substantial hardship for the client. So I just absolutely do not think any of them are going to be disqualified because they are not going to be found to be a necessary witness at trial. That's my opinion. Now, if the judge disagrees and the judge says, I am going to disqualify you because I found that you are a necessary witness, right? This trial is getting delayed. No way it's happening April 1st. No way it's happening April 25th. This is going to be something that's litigated, fought, continued, and eventually we will get to trial, which again makes me even more confident in what I think Judge Cannoni is going to do and not disqualify them for being on the witness list. Additionally, we read through the motion by Hank Brennan. I don't remember seeing anything in there that said, and we need David Yanetti to be a witness to these statements or these facts. He is a necessary witness. We are going to have to call him now because of this issue. I didn't see any of that. That's something he could have put in the motion and didn't. But this is a big deal. And this is why it's dangerous. It's risky. In my opinion, in most cases, not a good idea for a criminal defendant waiting for trial to go out and do public interviews. We said it with Alec Baldwin. We said it with Karen Reed. But it's done a lot of good in this case. I get it. So it's up to you guys. Do you think it was worth it? Do you think the pros outweighed the cons? Do you think the risk outweighed the benefits or vice versa from doing these public interviews, now knowing these statements could potentially come in? Now you'd have to think the jurors probably haven't seen these interviews. So is it going to be picked and chosen what statements are made? How much context are the statements going to be given? That's all something to me that would have to be litigated at length. And again, 1 week till trial. Do we have time to litigate those issues? I can't wait to see what the judge does. But it just shows how much work and how much just crazy things happen in this case that are abnormal, not like a normal case. So much work is still to be done between now and April 1st. I still think Judge Cannoni will end up pushing this case to April 25th, even if they pick a jury quick. But I don't know what you guys have to say. I'm going to read the comments, see what you think about all this. If you agree or disagree that she has at least intentionally waived her attorney-client privilege to a very limited set of facts and circumstances and statements made by Attorney Yanetti. That's all we got for this one. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.